And welcome back. Late in September, the New York sick leave law went into effect. Under the law, companies must provide employees 1 hour of paid or unpaid sick leave for every 30 hours worked by an employee. Now, although employers must pay the employee at the regular rate of pay, they can provide additional benefits to the employees as part of their sick leave policy in light of the COVID-19 pandemic. Many individuals wonder how this law will be implemented. And here to share a little bit more with us is attorney Jeffrey W. Pagano. And Jeffrey, good to have you.
Nice to see you today. Hope all is well. Hope all is safe for you and your family.
Yeah, same here. And we're just trying to make it and try to stay safe. But as we talk about family, of course, this law in particular really gives some help to those people who possibly may be dealing with this issue of sick leave. So walk us through exactly what the law calls for.
Well, the largest point that I can make is it's a misnomer to call it a sick leave.
Okay.
It's really about leave for specific purposes. And the first way of looking at it, well, who gets it? And then the second way is, well, what is it that what people get? And from my perspective, employers who are very small, those who are four employees or below, if they exceed $1 million in revenue, then bottom line is they have to provide it. So, and again, what is it? It's 40 hours effective January 1 or the anniversary of the person's hired. Now, keep in mind, it's a moving target because the government, both New York State and New York City, keeps issuing, alerts and guidance. So as a practical matter, what the whole scheme is about is how do we give people time to address things that typically arise in the home or within the family and not have them jeopardize their jobs in the process. Yeah. So for example, it applies to, now keep in mind, if you're over 100 employees, you have to provide 56 hours. Now, New York City has had this in effect for years. And so since 2014. So in a way, New York City is now upping their process to the New York State process. For example, it used to be in New York City that you had to have a certain waiting period. The waiting period's over with, or you had to accrue, or you had to work so many hours. That's eliminated. As of right now, as of September 30th, all employers are accruing for full and part-time employees, including seasonal employees, sick leave that will be effective January 1. Now, the usages, which is really why people ought not to think of it as sick leave, is what's important to understand. For example, an employee's or employee's family members' mental or physical illness or injury, right, or health condition, the diagnosis or care of an employee's or their family member mental or physical illness, injury, or health condition.
Let me ask jump in here, ask the question. I also understand that stalking, possibly human trafficking, yes, these are things that are also included in this as well.
Yes, in fact, yes, it's stalking. It's, the care for the child whose school or child care has somehow been eliminated. And really where it gets to is it allows you the time off to participate in the process. So for example, stalking, the time off it's necessary to contact the police or to contact an attorney is time off that's within the sick leave. So in a way, life's harm is covered by sick leave. And so an employer cannot eliminate the person's employment as a consequence of these events occurring in the person's life, the employee, or a family member. So if you're a guardian, this course would apply.
Yeah, but when we hear from employers, sometimes there's a little bit of a pushback, right? And the pushback for employers is saying this is a little bit too much. As an attorney, how do you weigh this out?
You know, I represent primarily employers, and my vision always has been compliance.
Hmm.
And an employer who has an ethic of compliance retains its employees. Now some may say, Jeff, it's easy for you to say, you don't have to spend the money. But at the end of the day, why afford employment attorneys on the plaintiff side, be it against a restaurant in New York City or out here in the East End or wherever? Why provide the money to them? Provide it to your people. And keep in mind, the 40 hours you can either front load or accrue. Now, the accrual is based on hours worked. So bottom line is, after 1,200 hours, the employee will have the 40 hours of sick leave each year, if that's the way you're going to do it. Or you can front load it and give it to him, or her. But keep in mind, it is true what you're saying. The difficulty on the employer's side will be this. Number one, you can't ask for the specific situation. All you can ask for is a general, basically, I would call a general reason for you to put in your notes. Because confidential information need not be disclosed by the employee. So it will be subject to abuse. You can discipline the employee for the improper use of it, but it's only afterwards. So for example, an employee extends his or her vacation by a day by claiming sick leave, and you discover it afterwards. That could be a dischargeable event. But if it's just a day off and you are been given the representation in oral or written form by the employee that my grandmother is very ill and I need to take care of her, you're probably going to have to, without other evidence of partying or going on vacation, you're going to have to pay out the sick day. So yes, it is subject to abuse. And the employers are basically limited in what they can request, because again, no confidential information such as medical condition or care need be disclosed, be it of the employee, the parent, the grandparents, the children, the stepchildren, the foster children, the guardian ad litem children, et cetera, et cetera.
Yeah. Before we go, I got one final question for you. Is there any process on the part of employers, as you said, you represent employers? Is there any process in part that can actually grant some appeal or of the law or look to reform it more to the employer's benefit?
No. And simply put, it is what it is. It's signed by Governor Cuomo. Look, the key for employers is compliance with the weekly payroll information that is necessary to account for that which has been accrued and that which has been used each payroll period. Where the employers are going to get caught is the lack of compliance and the lack of notice. A, the posting, and B, they have a posting that's issued, go on the New York State website and the New York City website. You'll see the posting. Number two, you have to give them the notice of it when they're hired. What is the sick pay? And number three, the weekly checks must include information as to the accrual and use of sick leave. If you're compliant in that regard, you probably will not have a problem as long as you are allowing them the days off.
All right. Well, we have to leave it there, Jeffrey. Thank you so much for joining us. Of course, we'll be able to follow this story and more as we get into the new year. Thanks so much for joining us.
Thank you. Have a good day.
All righty. Well, we want you to stay with us here on Open. We do have more show coming up. Open will return right after this.